Assalamualaikum, I'm Siti Nurhidayah binti Cik Rani 263447. So this time I'm going to present part 1 case situation. This case mentioned both party, which is Kavita versus Malaya Banking. The claimant was fired on 26 June 2019 for threatening remarks with bad words at Jeremy Teo Wee Sheng COW1. Case was heard for the first time in Industrial Court on 2 February 2020. The last four positions held by the claimant before dismissed was as Executive Data and System Analytics at the Malayan Banking Berhad. The organisation was based in Kuala Lumpur, Malaysia. So now let's go to the chronology of the cases. On 3 January 2005, the claimant started working for the bank as an accounting officer at Maybank, and her career was confirmed on 3 July 2005. After that, on 1 April 2012, she was assigned to a bank that specialized in non-retail credit risk reporting and analytics. Unfortunately, on 12 April 2019, there was complaint about the claimant when she raised her voice with bad words toward Jeremy Teo Wee Sheng COW1. Because of the complaint, on 28 May 2019, she was dismissed as she denied of saying bad words toward COW1. So, on 31st May 2019, the bank issued a show cause letter that the claimant was given written instruction to explain why disciplinary action should not be taken against her. So, the bank gave an extension of time to submit her explanation. By 18 June 2019, the claimant submit her explanation by an email to the respondent. On 26 June 2019, the staff group committee that considering all the relevant facts and they did not satisfied with the claimant explanation. So the claimant was dismissed from working with the bank. On 12 July 2019, the bank stick with their decision, although claimant appealed against them. Part 2. 1. Whether the dismissal of claimant is with just cause or excuse. Second, whether the claimant had committed racist misconduct. On 26 June 2019, Malayan Banking Berhad terminated the claimant's employment. The claimant was fired from the bank due to her commit serious misconduct when she raised her voice and threatening remarks with awful words at COW1. 3. Whether the claimant's misconduct was serious enough to justify dismissal.
Assalamualaikum, my name is Nur Fatihah binti Wan Zawdi, matric number 263577. Okay, today I will present for my part is for part 3, issue for the employees. Okay, in this case we have two charges for claimant. Okay, for charge 1, the claimant has raised her voice in Jeremy Teo Wee Sheng as the COW1 while making disparaging, derogatory, discrediting as well as threatening remark with vulgar word. Okay, not only that, the claimant also give a statement that claimant respond that the claimant had acted so because of the way COW1 deal with the claimant. The claimant had become upset, which eventually caused it to erupt during a conversation with COW1 on 12 April 2019. Okay, not only that, the claimant also give evidence to prove that she not forced in this case. The claimant stated that on 12 April 2019, during her conversation with COW1, there was an assigning on her part because of her long list of dissatisfaction with COW1 in connection with her pay report arising from her performance assessment as ineligible for financial year 2018 and her placement under consequent management program, where COW1 did not give a satisfactory answer to the claimant even though he had followed up. Okay, from the statement and evidence have given for claimant, we can conclude that they already have problem before this between the claimant with the Jeremy Teo Wee Sheng as COW1. Okay, that's all. Next. Okay, next I want to share for charge 2. The charge have give to the claimant the dishonesty of the claimant in daring indecent remark against Jeremy Teo Wee Sheng as a COW1 during the investigative interview conduct on 28 May 2019. Okay, the claimant give a statement to the judge that state that she only expressed dissatisfaction with COW1 during the investigative interview, and the claimant also asserted that she never said abuse word during the investigative interview on 28 May 2019. The Besides that, the claimant also give evidence to the court during the investigative interview. The conversation lasted only less than 5 minutes only, but the recording produced to the court show that the conversation was much longer than what the claimant said during the investigative interview. Okay. Next, not only that, the claimant also said that she had appealed to the bank to not dismiss and applied for his salary not to be deducted, but the bank remaining, and with this the decision that had been made, and also dismissed the claimant without giving space to claimant defend himself. So, okay, that's all from my part. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nolena binti Nordi and my metric number is 264220. Today I would like to explain about the issue for the respondent. For the charge 1, there was a complaint against the claimant in that the claimant had on 12 April 2019 raised her voice at Jeremy Teo Wee Sheng, COW1, whilst making disparaging, derogatory, regarding as well as threatening remark with vulgar words in relation to COW1. For the respondent evidence to the charge 1, COW1 gave evidence that the claimant approached his desk when she was notified about the conversation log in my HR2U system and start shouting at him. The claimant also rejected the invitation when the COW1 want to speak in privately. The claimant also start shouting while talking about the conversation log and slapping her hand into the COW1's workstation partition. The claimant also start hurling abusive words and engaged in vulgar uttering against him. The second charge of misconduct against the claimant involved the claimant's dishonesty in denying the uttering of any vulgar words against COW1 during the investigative interview which was conducted on the 28 May 2019. The claimant also gave a different answer on what happened 12 April 2019 during investigative. Second charge for respondent evidence is without the knowledge of claimant, the respondent actually have an evidence that he is record conversation during the incident on 12 April 2019. The recording actually for him for the purpose of preparing conversation log that has important fact. But the respondent continued the recording with the claimant because previously the claimant had shown a tendency to say something during the conversation to later deny or contradict them.
My name is Nurul Izzati binti Mahadi. Matrix number 263553. I will present part 5. Industrial Relations Act 1967. Section 20, subsection 1 address that the employee who have been dismissed by the employer without just cause or accused can make representation. Regarding to the case, the claimant claimed that her dismissal was without just cause or accused by Malayan Banking Berhad, so that she made representation to be reinstated to her former position without losing her wages, seniority and other benefits. Employment Act 1955. Section 14, subsection 1 address the actions can be taken by the employer on the employee after doing domestic inquiry or proper investigation. Regarding to the case, the respondent had performed proper investigation, which is investigative interview where the claimant has given opportunity to defend herself. During the investigation interview, the respondent proven that the claimant had indeed committed the said misconduct through the recording of the conversation that was played back during the investigative interview. The respondent issued the claimant a showcase letter and instructed her to provide written explanation. This showed that the respondent had done their part as recommended by the Act. complied with the law. Section 14, subsection 2 address the minimum wages can be paid by the employer to the employee during the suspension period. Based on the case, the respondent informed the claimant that she will be paid half of her wages during the 2 weeks of suspension period and full pay thereafter. Next is common law. There are two principles of natural justice which are let the other side be heard. This means that no one should be judged without a fair hearing, fairly and without bias. They should be given opportunity to give their explanation and evidence. And then no one can be judged on their own cause. Based on the case, respondent did not conduct domestic inquiry, but they had performed a proper investigation. Besides, the respondent also provide recording of the conversation between the claimant and COW1 during the incident. And this shows that the respondent did not breach the principle of natural justice, where the proper investigation had been conducted to let the claimant explanation to be heard. Next is implied terms in employment contract. An employee shall have a duty to act in good faith and provide faithful services. Referring to the case, the claimant denied that she uttered the vulgar words against COW1 during the investigative interview. The claimant breached this duty because she had done dishonestly actions and did not admit her guilt. Lastly, Code of Conduct for Industrial Harmony 1975. An employer should ensure that a fair, effective and expeditious procedure when dealing with disciplinary matters. In this case, the respondent had conducted the proper investigation, which is investigative interview, and also issued the claimant a showcase letter to provide her written explanation on the serious misconduct that committed by her.
Assalamualaikum. Case 1, Part C. Encik Roslan bin Yusof vs. Toyo Chem Sdn Bhd. This case is related to the first charge of Kavita uttering vulgar word toward his immediate superior. In this case, the claimant has uttered vulgar word toward his immediate superior, Encik Tarmiti bin Kasiron, and refusing to accept the letter from the company by throwing the letter to the ground. The claimant had replied to the showcase letter and he admitted that he uttered those words, but the word was directed toward himself, not toward his immediate superior. The company found his explanation was unsatisfactory and led to issue a domestic inquiry, which resulted him found guilty and led to termination of contract of employment. Case 2, Part C. Encik Mazli Muhammad Noor vs. KL Airport Services Sdn Bhd. This case is also related to the first charge of Kavita uttering vulgar word toward her immediate superior. In this case, a new instruction had been given to the staff where they did not have to use the logbook anymore, but the claimant ignored the instruction. Because of that, he was questioned by his supervisor, Encik Amir Shakib, on why he continued to use the logbook, and the claimant responded using abusive remark while raising his voice. And because of that, it led to showcase letter and domestic inquiry, which resulted he found guilty. And because of his poor disciplinary record in the past, the company decided to terminate his contract of employment. Case 3, Part C. Dewan Asmana and Lelaki Esparam vs. Westa Aviation Services Sdn Bhd. In this case, is related to the second charge of Kavita, dishonesty in denying misconduct during investigative interview. In this case, the claimant had breached the duty to act in good faith, where the claimant had misled the management to the reduction for the distribution of duit raya and misled the management to the list of the members who are eligible for the annual increment and manipulate the accommodation to secure the result for the annual increment eligibility, and other several misconduct which are too long for me to explain. But we need to know that the claimant had done too many misconduct that the company had decided to terminate the claimant contract of employment without doing domestic inquiry, but with proper investigation because the company are unable to trust their claimant anymore.
Part 7. Conclusion. Malayan Banking Berhad successfully proved to the satisfaction of this court that the dismissal of the claimant from her employment is due to the claimant's mistake by raised her voice threatening remark with vulgar words to COW1. Within the facts of the case, our group agree with the court decision to dismiss claimant from her employment because of her discipline issue. That's all from us. Thank you.